If you've received a traffic ticket in the state of Colorado and the officer who gave it to you said that you have the option to pay the penalty through the mail without having to go to court, this video is for you. Tickets like this are for what are called traffic infractions. Traffic infractions are civil offences for which you can only be fined and cannot be punished by being sent to jail. You may be watching this video because you want to fight the ticket, or simply do not have the money to pay it. You may be concerned about what happens if you now have to go to court. Perhaps you can pay the ticket but are concerned about the consequences for your driver's license, your employment, or the possible increase in the cost of your auto insurance.
You can generally trust what the officer said about if and when you have to go to court. If you are in any doubt, you can call the court or the agency that issued the ticket. You can also read your ticket to find this out. If you find that your ticket or this video are too hard to understand, or if you want someone to advise you about your specific circumstances, talk to a lawyer. Another resource is the Self-Help Center, or Self-Represented Litigant Coordinator in one of Colorado's courts. Let's look at a traffic ticket and see whether it is for a traffic infraction. This form is called a Uniform Summons and Complaint Penalty Assessment. Most police departments use something similar, but this particular one is from Colorado Springs and is available online if you want to look at it more closely. We are focusing on the part that has your signature on it. On this form, you are referred to as the defendant.
If you're charged with a traffic infraction, when you receive the ticket, you are asked to sign in the box checked for payable summons and complaint or penalty assessment. The box for traffic infraction is also checked. The words that follow are very important. Immediately above your signature, you're given the option to pay the ticket within 20 days, waive a series of rights listed on the back of the ticket, and acknowledge guilt of all charges, with the understanding that points will be assessed against your driver's license. Look at your own ticket and find your signature. What does your ticket say in the section where you signed? If you were given the option to acknowledge guilt and pay a penalty without going to court, then this video is for you.
Now look at what the officer thought you did wrong. As you focus on the middle of the form, you will see there is one charge of speeding, 10 to 19 miles over the speed limit. The fine is given as $135. There is a surcharge of $16 and 4 points will be assessed on your driver's license if you choose to pay this. At the far left, the Colorado law you are believed to have violated is referred to as the Colorado Revised Statute Section 42-4-1101(1).
If you believe you were not guilty and did not do what the officer said you did, and you want to fight the ticket and take this case to trial, this video, along with the next, will show you the steps involved. Perhaps you don't dispute or disagree with the charge, but are unable to pay, or you are undecided about whether to fight the ticket, or perhaps there is an automatic plea deal offered on the back of the ticket that will give you reduced points if you pay quickly. Let's take a few minutes to consider these possibilities. Now is the time to think about your driving record and your finances. Perhaps you have a job that requires a clean driver's license. Maybe you have accumulated so many points and are worried you will lose your license if you get additional points. If you need to drive in order to work, this situation may be far more costly than the penalty you would have to pay for the ticket. If any of these are your situation, this may be the time to talk to your employer, or to get a lawyer, or at least get in touch with the DMV to understand the full consequences of your ticket.
It is especially important to check into your driving record if you are under 21. Young drivers lose their licenses due to points when they have far fewer points than older drivers. The Department of Motor Vehicles website is provided in the link below this video. Get help if you need it, but act quickly so you don't miss any deadlines. such as a deadline to pay in time to avoid court or your actual court date. Any delay can be expensive, and here is why. Perhaps you've heard that if the officer fails to come to court for your hearing, you will win, meaning the case will be dismissed without cost to you. Actually, the officer is not required to attend until the second hearing, so you will have to appear in court at least twice. Some people do have their case dismissed when the officer does not appear at the second hearing or at the trial. But if the officer does appear in court and you lose the case, the total cost to you at the end of the court case can be much more expensive than what was shown on the original ticket. And here is why. Court charges change frequently. These are approximate estimates only. After 20 days, the court costs, including docket fee. This varies, but likely an extra $25. Payment plan, add more court costs, varies, but about $30. Leaving ticket unpaid, add outstanding judgment warrant, $30.
If you pay within 20 days, the case is kept out of the courts. Therefore, you only pay the total penalty and surcharge listed on the ticket. That payment usually goes to the city or county sheriff's department which ticketed you. If you pay within 20 days, you may get reduced points from an automatic guilty plea as described on the back of your ticket. After 20 days, the agency that ticketed you will file the ticket with the court, and the court will then charge court costs, including a docket fee. These fees are in addition to the surcharges on the ticket, although you only have to pay these fees if you admit guilt or lose your case. However, the court costs will sometimes be even more than the penalty amount. It is especially important to understand that once the case has gone to court, you have lost the chance to pay the ticketing agency directly or to take advantage of any automatic plea deal that is offered on the back of the ticket.
Once your ticket becomes a case at the court, if you lose the case and you cannot pay, the court may impose an additional charge if you ask for a payment plan. For example, Boulder Municipal Court charges an additional fee to stay, which means to make payments on, a fine. In addition, if you don't pay what you owe, an outstanding judgment warrant, or OJW, will be charged to you. You must pay this additional fee along with everything else before you can renew your driver's license. The bottom line is that if you think that the officer was right to give you the ticket, expect the costs to rise steeply the longer you spend taking care of the ticket.
If you do not pay the ticket within 20 days, then all you have agreed to do is to be in court at the date, time, and place written on the ticket. You have not admitted any guilt, and if you go to court, the prosecuting officer will have to prove you guilty. We'll discuss how to take the matter to court or trial in another video. Once you are in a court, there are rules that are followed. In this video, we'll focus on what happens in the county courts of Colorado, where many traffic tickets are handled. The rules for Colorado courts are online. You can find a link to the rules below this video. You can also get help from your public library and your court self-help center to find these rules.
Many towns and cities often operate their own municipal courts. Their rules can be different. Again, the public libraries or local court staff can help you find the municipal court rules. If you look at the form from Colorado Springs, the officer has checked the box for El Paso County Court, but could have checked the box for Colorado Springs Municipal Court. The difference is very important. For example, in Colorado County courts, technical rules of evidence do not apply in traffic ticket cases. Therefore, the procedure can be more friendly if you don't have a lawyer. By contrast, in some municipal courts, more technical rules apply, and you may want a lawyer's help.
Notice that the El Paso County Court and the Colorado Springs Municipal Court are both in Colorado Springs, but at different physical addresses. Make sure you go to the right courthouse. Many people are unaware that there can be more than one court in the same city. This is not unusual. Another example is Adams County, where both the Adams County Court and the Brighton Municipal Court are in the city of Brighton, but located at different physical locations.
When you signed your ticket, you agreed to appear at the correct time and place. If you fail to get to the right place in court on time, you will lose your case. If you do not appear, you will automatically lose your case, and you will have to pay the ticket and the court costs and an outstanding judgment warrant, OJW, fee if you still fail to pay. As you can see, not getting to the right court on time can be an expensive mistake. Rule 15. Continuances may be granted on a showing of good cause by the officer, his supervisor, or the defendant. If your ticket is in a county court and you know that you cannot make the court date on your ticket, you can fill out Form JDF 76 from the state court website to request a new court date. On the form, explain the reason why you can't be in the court on that date and/or time, and ask the court to give you a different court date. If you're in a municipal court, find the court's website for the form to request another court date. Municipal courts often have their own forms and procedures.
Most judges will let you continue, which means get a new court date. And they'll let you do it one time only for a good reason, such as travel or a doctor's appointment. For those of you thinking of fighting your ticket and hoping that the officer will not show up, beware that the law on continuances, or asking for a different court date, is the same for the officer. Either side can request a new and more convenient court date. Rule 16A, Default. If the defendant fails to appear for any hearing, the referee shall enter judgment against the defendant. But, C, the court may set aside a judgment entered under this rule on a showing of good cause or excusable neglect by the defendant. A motion to set aside the judgment shall be made to the court not more than 7 calendar days after entry of judgment. Suppose you have missed your court date. Is there anything you can do about it? The law says the court must rule against you, and you will lose if you fail to appear. The judge will enter an order saying that the day of the hearing. You can only have another chance if you file a motion to set aside that default not more than 7 days after the hearing date. You will have to write or tell the court that there was a good reason why you were not able to be in court when you should have been there.
If you are in a county court and you miss your court date, immediately download the Motion and Order to Set Aside Default Judgment Form, JDF Form 78, from the Colorado State Court website. Complete the caption by adding your name on the form and tell your story about why you missed the court date. Ask the court to set the default judgment aside and give you a new court date and another chance to tell your story. You should also provide a reason why you expect to win at the final hearing. Again, if you are in municipal court, find that town or city's website for a copy of the form, as they often have their own forms and procedure.
So you have decided to go to court, or perhaps you have no choice because you cannot pay on time. Let's assume you made it on time to the correct courthouse. Here is what to expect. You will not be the only person in court that day. There may be 100 or more people with you, especially in the larger counties. It may be a much more personal experience in the smaller counties and in municipal courts with fewer cases. You will likely check in with the court staff, and you'll be given your rights, either on a piece of paper or verbally. You may be asked to read and sign a form to show you have received the advice. Don't expect to meet with a judge in every court. If English is not your first language or you have difficulty reading, ask for an interpreter or for help. You will be advised of the following rights. I'll say things using slightly different words to help you understand. You will be told, 1. What you did wrong, meaning the infractions listed on your ticket. 2. The fine and fees you will pay if you admit guilt or are found guilty, and the penalty points that can be assessed against your license and driving record.
3. What will happen if you fail to come to court for the next hearing, including that you will lose your case and that the judgment will be reported to the State Motor Vehicle Division, which can then assess points against your driver's license. 4. You have the right to find and hire a lawyer, but you have to pay for the lawyer yourself. 5. You have the right to fight the ticket and have the officer prove to the judge or magistrate that you did what he or she said you did.
6. At a hearing, you don't have to say anything. You have the right to remain silent. Any statements you make can be used against you. 7. Your guilt, meaning that you did what the officer said you did, must be proven beyond a reasonable doubt at a hearing or trial unless you choose to admit guilt. 8. You have the right to testify, meaning tell your side of the story at any hearing, and you can subpoena witnesses, present evidence, and cross-examine any witnesses called against you.
9. Any answer you make must be voluntary and not the result of undue influence or coercion on the part of anyone. But 10. If you admit guilt or liability for the infractions charged, this constitutes a waiver of these rights and you lose any right to appeal. Once the court is satisfied you have received and understood these rights, then you will be asked to make a plea of guilty or not guilty. This means you say you did or did not do it. If you say guilty, you will pay the total shown on the ticket and any court costs, including a docket fee. In county courts, you are expected to pay these amounts on the day of your hearing, so bring some means of payment with you. If you cannot pay when the court tells you that you have to pay, then you risk having to pay the additional fee or outstanding judgment warrant, OJW, before you can renew your driver's license.
If you say you are not guilty, the clerk will give you a date for your final hearing. This is a trial where the officer who ticketed you has to prove his case. Before the final hearing or trial, there may be some opportunity for plea bargaining, which means you can talk to the prosecutor, the lawyer for the county, city, or town where you received your ticket. Indeed, this may happen at your first appearance after you've been advised of your rights. We will cover both plea bargaining and how to proceed at trial in the next video.
Going to trial will cost you the inconvenience and, if you're working, time off resulting from another trip to court, but there is no additional court cost to pay beyond these fees. You only have to pay that if you lose. If you have the time and ability to return to court, there is the opportunity for a better outcome, either by plea bargaining or by winning at trial. These are the topics of the next video.